Good morning. This is Heidi Meyers, immigration attorney. We have a very good question from one of our viewers, one of our community, regarding TPS, temporary protected status, and whether or not travel on advance parole counts for the requirement to get your green card for adjustment to permanent residency of 8 U.S.C. section 1255A. So the question is, for someone who entered illegally and then later was granted TPS, temporary protected status, which according to the Supreme Court in Sanchez versus Garland is a lawful non-immigrant status, if they travel on advance parole and return to the United States, they'll be inspected and paroled by a CBP officer, whether that counts under section 1255A as either an inspection and admission or inspection and parole for purposes of adjustment of status. So that's the question. And the answer gets very complicated. So the BIA, the Board of Immigration Appeals, in matter of ZR-ZC, issued a decision stating that travel on advance parole by a TPS holder does not constitute inspection and parole for purposes of adjustment to permanent residency. This was issued August 20th, 2020. So before August 20th, 2020, USCIS's position was if you traveled abroad on advance parole and you were inspected and paroled, that counted, yes, for purposes of 8 U.S.C. 1255A as an inspection and parole for adjustment to permanent residency. So, for example, if you traveled on advance parole prior to August 20th, 2020, and you had an immediate relative petition, and you were have TPS, then yes, you could adjust to permanent residency. So remember, immediate relatives are only spouses, parents, and minor unmarried children of U.S. citizens. So even before August 20th, 2020, even though travel on advance parole counted as an inspection and parole for purposes of 8 U.S.C. 1255A, if you were applying for adjustment, say, based on an employment preference petition, you still needed to have shown that you maintained your lawful non-immigrant status, and generally people who have TPS have fallen out of status for certain periods of time. The same with a family preference petition. So that is, if you're not the immediate relative of a U.S. citizen. So for example, if you are the spouse or child of a permanent resident, or if you are trying to adjust based on some other family preference, then you still have to show that you've maintained your non-immigrant status the entire time you've been in the United States. So, however, for anyone traveling on advance parole after August 20th, 2020, USCIS has adopted the position that inspection and parole pursuant to the advance parole does not count for purposes of adjustment to permanent residency. So the difference is, if you enter the United States illegally without inspection, later you were granted temporary protected status, TPS, and you traveled abroad on advance parole and you were inspected and paroled by a CBP officer when you came back, now USCIS's position is that you do not qualify for adjustment to permanent residency, that inspection and parole did not qualify you under 8 U.S.C. 1255A. So this gets very, very complicated, as you can see, and if you're confused, well, it is confusing to many people. And if it doesn't seem to make sense, well, a lot of things in immigration don't seem to make a whole lot of sense. Okay, so however, so this is the current state of the law today, July 2nd, 2021. This could change. All right, so stay tuned. All right, so just a short video today on whether or not travel on advanced parole and you return to the United States, you're inspected and paroled by a U.S. immigration officer, by a CBP officer, whether that qualifies you or not for adjustment to permanent residency. This is Heidi Meyers, 11 Broadway, Suite 925, New York, New York, 10004. Our phone number is 212-791-4007 or 646-508-5225. And my email is heidimeyerslaw@gmail.com. And don't forget to like this video and subscribe to my channel. Thank you very much and have a great 4th of July weekend. Bye-bye.